Hello, I'm Eric Tars, the Human Rights and Children's Rights Program Director at the National Law Center on Homelessness and Poverty. Thanks to the Maryland Legal Aid Bureau for inviting me to celebrate Human Rights Day with you. Today I'm going to talk a little bit about using some human rights tools, the treaty shadow reporting process, in order to help you in your advocacy for the people of Maryland. First, I'm going to talk about the why, then the what, then the how of bringing human rights home. First, why do we as a national legal organization use these human rights processes? First, we use it to draw attention to the issues and give them specific human rights framing. So, for example, after the Torture Committee and Human Rights Committee hearings in 2006, our friends at Chicago's People's Law Office working on police abuse cases got huge media attention, and every news story referred not just to police abuse, but police torture. And after 20 years of working on these cases with no success, they finally got the perpetrators sent to jail and compensation for the victims. Second, we use it to create standards that we can actually use. The treaty language is broad. Quote, states parties shall, when the circumstances so warrant, take in the social, economic, and cultural and other fields special and concrete measures to ensure the adequate development and protection of certain racial groups or individuals belonging to them. End quote. If we want to say that that language means that we need to be doing more to resolve the disparate impact of homelessness on people of color to help our policy advocacy or litigation, we can get language very specific to that issue through these shadow reporting processes. Last but not least, we do it to maintain the record. While the recent report from the Obama administration doesn't have as many outright perversions of the law and the record as did the Bush administration's report in 2006, and while it is 112 pages long, what it doesn't say is as significant as what it does say, and we as advocates can't let that pass without setting the record straight. So that's why we do it, to draw attention to our issues, to get specific language to help us in our advocacy, and to keep the record straight. So having dealt with the why, the next question is, how do we do it? First, we need to understand, what is this treaty? It's the International Convention on the Elimination of All Forms of Racial Discrimination, which is abbreviated either CERD or CERD, but CERD alone also refers to the Committee on the Elimination of Racial Discrimination, which oversees the treaty. So for our purposes, we'll talk about the treaty as CERD and the committee as CERD. This treaty was adopted in 1965 as one of the first human rights treaties by the UN, but was not ratified by the U.S. until 1994. What does that require us to do? It requires us to eliminate discrimination in both purpose and effect, a very important standard for us here in the U.S., especially as our disparate impact standards are continuing to be challenged in courts and in legislatures. It also requires affirmative action to remedy past discrimination. And again, as these measures are continually challenged in our courts, turning to the language of the treaty, which we have ratified and should be binding as the supreme law of the land, can help us in our advocacy to keep those standards fresh in our system. Last but not least, the treaty requires us to report on our progress in implementing it every couple of years, and this gives us as advocates an opportunity to talk about our issues in the context of the treaty and work with federal, state, or local agencies to help them understand what their obligations should be in implementing the treaty. Right now, we're in the middle of this process, which has both formal and informal components operating in parallel. The formal dialogue is between the government and the treaty body, the Committee on the Elimination of Racial Discrimination. The first step is the U.S. issuing its report, as it is required to do every 2 years, theoretically, under the treaty, although most of the time it takes much longer than that. This committee will then issue what they call their list of themes that they feel are important issues to be discussed. This committee will review the U.S. formally in Geneva with a large government delegation before them, and then the committee will issue concluding observations and recommendations on steps the U.S. should take to further implement the treaty. We as advocates can inform the process by first informing the content of the U.S. report itself, analyzing the report, and drafting reports to the committee to help them further understand the issues that we feel are important under the treaty. meeting with them in Geneva, and then most importantly, using the observations in our own advocacy. Where are we in this process right now? The U.S. has already reported in June of this year, and the CERD will be developing its list of themes in the spring of next year. The committee will review the U.S. in August and issue their concluding observations later that month. So for us as advocates, we've already missed our window to actually inform the U.S. report, although this is a periodic process and that opportunity will come up again. But what we should be doing right now is analyzing the U.S. report, drafting our shadow reports to inform the committee's advocacy and questions with the U.S. government in Geneva, meeting with them in August, and then continuing to use the observations throughout the next 4 years as part of our own advocacy. So what does this look like? Here's the table of contents of the U.S. report. Just the first page of it, as I said, it's over 100 pages long. It came out over 1 year late, and it covers a full range of civil, political, economic, social, and cultural rights. So everything from the right to vote to criminal justice issues, racial profiling, housing, education, healthcare, you name it, it's in the report, and there's a lot of information there. We at the National Law Center actually took the report and pulled out all of the housing references in particular and came out with 14 pages just on those housing issues, which we can share with you as part of your own analysis. And then we take a look as we begin our drafting process at the rights that are in the treaty, the right to non-discrimination, collective political rights, economic, social, and cultural rights, as well as the right to an effective remedy. And we see where do our issues fit in with that. How do we talk about access to the right to vote for people who have no homes, the disparate impact of criminalization on communities of color, the lack of affordable housing that disparately impacts communities of color, access to counsel, and other issues. We'll bring these issues to the committee in Geneva, where we'll meet with them both in formal and in informal briefing sessions to talk through the issues, to meet with international media, to really help to generate an international spotlight. This is a great opportunity to bring clients or other grassroots advocates into the process to help give the directly affected voice to the committee and have the incredibly empowering experience of having those directly affected victims of human rights abuses see the U.S. government grilled by an international committee holding them accountable to human rights standards. What comes out of this process? It's called the concluding observations from the committee, which, again, can be very specific to issues that you're working on. In the last round, we got specific references to the California Housing Element Law, which specifically mandates inclusionary zoning processes. We also got a positive mention to the Violence Against Women Act revisions that's protected women and children in domestic violence situations from being discriminated against in federally funded housing. We also got the committee to specifically criticize broadly laws that are enforced with discriminatory effect, but then some very specific references to segregated and substandard housing and access to civil counsel and other issues that we use on a daily basis in our advocacy. These observations can be worded very specifically to help with our advocacy. For example, one of these from last time that looks directly at the use of discriminatory impact language was directed both at the political process and at the courts at the intervention of lawyers such as us who knew that it was important to use these standards and emphasize their application in both of these settings. In terms of how we use these standards once we get them, for example, after Hurricane Katrina, the number of homeless people in New Orleans doubled from 6,000 to 12,000. Rather than taking a constructive approach to ending homelessness, the City Council considered an ordinance that would have banned sleeping on city streets, as a tent city made the problems of homelessness very visible in their community. Through the shadow reporting process, we generated a tremendous amount of press coverage for the human rights violations going on in the Gulf Coast, and then got concluding observations specific to the situation in New Orleans. We drafted a letter to the City Council combining constitutional arguments with encouragement to follow the recommendations from the committee. We emphasized that after Hurricane Katrina, the eyes of the world were on New Orleans, and why would they go flaunting the rights of their most vulnerable citizens when they knew that the eyes of the world were on them? In addition to the concluding observations themselves, the U.S. often makes many statements at the international saying how we are promoting human rights domestically, not just at the federal level, but at the state and local level. We can use these statements both in our courtroom advocacy to emphasize the legitimacy of our arguments, as well as in our policy advocacy. And, as a result of this advocacy, as well as that of many others, the ordinance I mentioned was defeated, and ultimately almost all of the people in the tent community were settled into permanent housing. So, we've talked about why doing this, in order to create the standards and highlight issues that are important to us. We talked about how we use the process, looking to the international standards, applying them to our issues, and getting the concluding observations. And then we talked about bringing these human rights standards home, putting them into effect in our communities through policy advocacy, through litigation. I'm happy to talk more with folks about how you can be a shadow reporter for justice, bringing the CERD standards into your community and generating justice for people of Maryland. Feel free to get in touch with me at the number on your screen. I also have an article in the Clearinghouse Review called on shadow reporting processes, and I'll be happy to share with you if you want to look more at the details about that. So with that, again, thank you for letting me share human rights today with you. Happy Human Rights Day.